Good morning. Welcome to today's Public Service Commission's administrative meetings agenda. I apologize to those of you who waited for an interminable period in the lobby. We're having problems with our elevators, and we've had problems for a while, and it's frustrating for both for you and for us. Yeah, it's been at least 6 months.
Yeah. 9?
Anyhow, we will get going. We have a long meeting today ahead of us, or at least a number of items on the agenda. We have minutes from the last meeting, which was on September the 12th. Is that right? 12th. Do you have a motion to approve the minutes?
Yes, Mr. Chairman. I move we adopt the minutes from the September 12th administrative meeting.
All in favor?
Aye.
The minutes are approved. Madam Secretary, the administrative agenda.
Yes, Mr. Chairman. We have no consent agenda today. The first item on the administrative agenda is Verizon Maryland LLC and GC Pivotal LLC DBA Global Capacity, filed on August 20, 2018, a request for approval of amendment number 4 to an interconnection agreement under Section 252E of the Telecommunications Act of 1996.
Thank you. And if counsel for any of the parties representing matters before us today would like to approach the other podium, please do so. Mr. Spivak.
Thank you. Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. This is the joint application of Verizon Maryland LLC and GC Pivotal LLC doing business as Global Capacity for approval of an amendment number 4 to an interconnection agreement. Pursuant to 47 U.S. Code Section 252A1, upon request by a requesting telecommunications carrier for interconnection services or network elements pursuant to that section of the code, Verizon may negotiate and enter into a binding interconnection agreement with the carrier, which may be amended from time to time as the parties agree. The agreement or an amendment must be submitted to the Commission under 47 U.S. Code Section 252E for approval. If the State Commission does not act to approve or reject the agreement or amendment within 90 days after submission by the parties, adopted by negotiation, the agreement shall be deemed approved. 47 U.S. Code Section 252E provides that the State Commission may only reject an agreement or an amendment adopted by negotiation if it finds that either the agreement or a portion thereof discriminates against a telecommunications carrier not a party to the agreement, or the implementation of the agreement or amendment is not consistent with the public interest, convenience, and necessity. The Verizon Global Capacity Amendment was negotiated by the parties and limits Verizon's obligation to provide unbundled network elements pursuant to previous FCC and court orders. As required by 47 U.S.C. Section 251A1 and 252E, Verizon and Global Capacity have filed for the amendment for Commission approval. Staff has reviewed the amendment for compliance with the Act and finds that it neither discriminates against non-party telecommunication carriers nor appears to be inconsistent with public interest, convenience, and necessity. Staff therefore recommends that the Commission allow a 30-day period from today for any carrier that believes that all or a portion of the amendment should be rejected to file comments. Staff further recommends that the Commission approve the amendment 10 days after the end of that period, unless comments are received by the Commission prior to that date.
Thank you, sir. Any questions for Mr. Spivak or Margaret? No. Thank you. Is there a motion?
Yes, Mr. Chairman. I would move that we approve the interconnection agreement 10 days following a 30-day comment period, assuming no adverse comments are submitted.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved. Madam Secretary, perhaps we could take items 2, 3, and 4 together.
Yes, Mr. Chairman. Item 2, all of the items are requests to cancel licenses to operate either as an electricity or natural gas broker in Maryland. The second item was filed by Crosslink Advisors, LLC on August 30th, 2018. The third item was Mohire Companies, Inc., filed on August 20th, 2018. The fourth item is Axiom Retail Energy, LLC, filed on August 13, 2018. And the fifth item is Mint Energy, LLC, filed on August 7, 2018.
I'm sorry, did I hear you refer to the fifth item as well?
Yes, yeah,
Two
Okay.
through five.
2 through 5, okay. These 4 items are similar. They each refer to a supplier is asking the commission to terminate their authorization. None of the suppliers are serving any customers right now in Maryland. None of them have open complaints. I would note that 2 of them, Axiom and Crosslink, as indicated in their filing, were assessed a $100 penalty for failing to report their gross operating revenues, which we use as the basis for the annual assessment. Staff recommends that the Commission terminate the company's licenses to serve as suppliers.
great. Thank you, Mr. Albert. Do commissioners have questions on items 2, 3, 4, or 5? Seeing none, is there a motion?
Yes, Mr. Chairman. For Crosslink, for an item number 2, Crosslink Advisors LLC. For item number 3, Mohair Companies, Inc., and for item number 5, Mint Energy LLC, I move we cancel the company's licenses to operate as electricity suppliers in Maryland. For item number, let me make sure I got that right. Actually, no. Item number 2, 4, and 5, I move we cancel the company's licenses to operate as electricity suppliers in Maryland. And for item number 3, for Mohair Companies, Inc., I move we cancel the company's license to operate as electricity and natural gas broker in Maryland.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is to approve items 2, 3, 4, and 5. It's like a global settlement, except we're not dealing with defendants. That was always fun, having multiple plea deals happen in the afternoon, and the judge would just go right down the line. Saves a lot of time. Item number 6, Madam Secretary.
Item number 6 is NJR Retail Services Company, filed on August 1, 2018, notification of the name change to Direct Energy RS Gas, Inc.
Good morning, Chairman and Commissioners. Peter Wolson on behalf of staff. NJR Retail Services Company has operated under a Maryland license to supply natural gas since July 2017, serving commercial customers only. The company was purchased by Direct Energy Business Marketing, LLC, in March of 2018, and this transaction was noted by the Commission. The company has now given notice to the Commission that it has changed its name to Direct Energy RS Gas, Inc. There's been no change in operation of the company, nor is there any change in customer contracts or service. Neither are there open complaints or assessments owed by the company. Accordingly, staff recommends that the Commission note the filing and the change of name.
Thank you, Mr. Wolson. Any questions? Seeing none, is there a motion?
Yes, Mr. Chairman, I move we note the filing.
Thank you. Is there a second?
Second.
All in favor?
Aye.
Aye.
The motion is approved. The filing is noted.
We can take items number 7 and 8 together. They Cost Control Associates, Inc., filed on July 9, 2018, an application for a license to supply natural gas or natural gas supply services in Maryland, and an application for a license to supply electricity or electric generation services in Maryland.
I apologize, I was dealing with the next fire. So Cost Control Associates seeks authority to operate as a broker of electricity under Public Utilities Article 7507 and a broker of gas under Public Utilities Article 7602. The company proposes to serve commercial and industrial customers throughout the state. Under the statute, Cost Control must prove technical and managerial competence, financial integrity, and compliance with applicable state and federal regulatory requirements relating to the sale of electricity and gas in the state and the conduct of business in Maryland. Cost Control operates as an energy broker in 6 states, which operation provides the company with experience in the energy brokering industry. Staff found no evidence of complaints or illegal operations. Cost Control has submitted a $10,000 bond, which for a broker may be accepted as proof of financial integrity. The company is in good standing to do business in Maryland, and the company has also executed an affidavit of general compliance by which it has agreed to comply with all applicable federal and state consumer protection and environmental laws and regulations. Staff recommends that the company grant cost controls applications to operate as an electricity supplier and gas supplier limited to operations as a broker, serving commercial and industrial customers throughout Maryland. Staff also recommends that the Commission direct the company to provide training and marketing materials specific to its Maryland operations 30 days prior to using those materials in Maryland, and to notify the Commission within 30 days of any changes to the information upon which the Commission relied in granting this license.
Thank you, Ms. Garofalo. Appreciate staff conducting these thorough reviews of these license applications. Do commissioners have any questions? Is there a motion?
Mr. Chairman, I move for items number 7 and 8, we grant the company a license to operate as a natural gas supplier and as an electricity supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff, and direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to the utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The two motions are approved. The license applications are accepted.
Item number 9 is Gotham Energy 360 LLC, filed on April 27, 2018, an application for a license to supply natural gas or natural gas supply services in Maryland.
Good morning again, Mr. Chairman, Commissioners. Kenneth Albert on behalf of staff. This is an application by Gotham Energy for authorization to operate as a natural gas broker and aggregator for commercial and industrial customers. Gotham has significant experience in the energy industry. We checked their performance in the other states where they operate. There are no complaints and there have been no enforcement proceedings. Based on its review, therefore, staff believes that it's appropriate to authorize Gotham to operate as a natural gas broker and aggregator, with the conditions recommended in staff's comments.
Thank you, Mr. Albert. Noting those conditions, do the commissioners have questions? Seeing none, is there a motion?
Yes, Mr. Chairman, I move that we grant the company a license to operate as a natural gas supplier in Maryland, limited to broker services for the customer classes and service territories applied for and recommended by staff. That we direct the company to provide marketing and training materials specific to its Maryland operations to the Commission staff 30 days prior to utilization of the materials in Maryland, and direct the company to file notice with the Commission within 30 days of any changes to the information in the application.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved.
Item number 10 is South Jersey Industries, Inc. and its subsidiaries SJI Utilities, Inc., and Elkton Gas Company, formerly known as Elkton Acquisition Corp., filed on August 23, 2018, copies of their most favored nation compliance filing required by paragraph 31 of the settlement agreement approved in Commission Order number 88718, case number 9475.
Peter Wilson again for staff. By this filing in case number 9475, which was the last Elkton Gas acquisition and merger case, South Jersey Industries and Elkton Gas Company gave notice of their intention to increase the per customer direct credit from $32 per customer as agreed in the settlement agreement and approved by the Commission to $51.52. The increase is made pursuant to the most favored nation clause in the settlement agreement, assuring Maryland customers equal treatment to New Jersey customers in any settlement of the Elizabethtown gas merger case in New Jersey. Elkton proposes to apply this credit to its customers' October bills. Staff has reviewed the company's filing and calculations and finds them in accord with the settlement and the Commission's order. Accordingly, staff recommends the Commission authorize Elkton to issue direct customer credits that total $333,437 as proposed by the company. Staff further recommends the Commission direct Elkton to provide an informational report not more than 60 days after credits are finalized that summarizes direct credits issued to Elkton customers.
Thank you, Mr. Wilson. Does Elkton Gas have any response?
Good morning, Mr. Chairman and Commissioners. Carville Collins on behalf of Pivotal Utility Holdings, Inc., which is doing business as Elkton Gas. On behalf of the company, just want to thank the staff for their recommendation and also for People's Counsel, which has recommended similarly. We are available if there are any questions the Commission may have.
Thank you, Mr. Collins. Collins, did I get that right? Okay,
Yes, Mr. Chairman.
thank you. Any questions for the parties?
Yes, thank you.
Is there a motion?
Yes, Mr. Chairman. For item number 10, I move we grant Elton Gas authority to issue direct customer credits that total $333,437 and direct that Elton Gas provide an informational report not more than 60 days after credits are finalized that summarizes direct credits issued to Elton Gas, Elton customers by class.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved. Thank you.
Item number 11 is the State of Maryland Office of the Attorney General filed on April 30th, 2018, petition for waiver of overrun and interruption penalties.
And do we have counsel for both Washington Gas and the University of Maryland present? Why don't you have a seat at the table? Mr. Spivak, whenever you're ready.
Thank you, Mr. Chairman. Good morning again. Lloyd Spivak for the Commission staff. This is a filing by the State of Maryland Office of the Attorney General on behalf of the University of Maryland, College Park, requesting a waiver of penalties in the Washington Gas Company tariff, Section 2 of the Interruptible Delivery Service tariff. UMCP takes gas service under the Interruptible Delivery Service rate schedule number 4 of WGL's tariff. Customers taking service under Schedule number 4 are required to reduce their gas consumption to zero, with the exception of pilot gas usage, within 2 hours of receiving notice of an interruption. UMCP failed to cease gas consumption on January 5th and 6th, 2018, and triggered the penalties under Section 2 of Schedule number 4. However, Section 2E allows customers meeting certain criteria to request a waiver of the penalties at the discretion of the Commission. The assessment reflected on UMCP's January bill for the period of noncompliance totals $1,668,850.54. Public Utilities Article, Section 4-501A2 provides that a public service company may not demand or collect compensation that differs from compensation specified in the rate schedules that are in force at the time of demand or collection. Under the company's tariff for rate schedule number 4, interruptible customers who fail to interrupt are subject to a penalty charge of $3 per therm used during the days of interruption for violating the interruption notice, and for those days that the customer failed to interrupt, paying the unauthorized consumption of gas charge rate equal to 1, the highest actual price paid during an interruption from a source from which actual purchases were made during the period of noncompliance, and 2, that number multiplied by a factor of 1.5. The tariff allows the Commission to waive these penalties upon a demonstration by the customer that the failure to interrupt was beyond the customer's control under the circumstances, including, but not limited to, an act of God, government action, riot or other civil disturbance, or mechanical failure upon proof that equipment was properly maintained, and the customer is able to demonstrate its good faith effort to comply with an interruption notice. WGL argues in its comments to the state's waiver request that only the overrun penalty of $3 per therm is eligible for waiver. Staff interprets the tariff to mean that the penalties assessed for failure to interrupt are the $3 per therm, plus the increment of 50% added to the price paid during the interruption. The price portion of the unauthorized consumption of gas charge rate we view as the cost WGL had to pay for gas during the interruption. The state, on behalf of UMCP, requests that the Commission waive the full amount of the penalty and provides its demonstration of good faith effort to comply with the interruption during the interruption event in accordance with the waiver provisions of the tariff. UMCP failed to interrupt gas usage on January 5th and 6th, 2018, due to a mechanical failure within the fuel nozzle component of the combustion turbine, which would have enabled UMCP to switch from gas to an alternative fuel. UMCP was not able to replace this nozzle in time for the winter season, and the temporary boiler it ordered as a stopgap could not be fully installed until February 2nd, 2018. Staff is persuaded that the mechanical failure experienced by UMCP's combustion turbine constitutes an event beyond control, and that UMCP demonstrated a good faith effort to comply with the interruption notice. Therefore, staff recommends that the Commission grant the penalty waiver. Staff further requests that the Commission accept staff's interpretation of the company's rate schedule number 4 tariff and direct the company to file tariff revisions by no later than 30 days prior to the 2018 through 19 heating season. The tariff revision should reflect staff's interpretation as outlined in staff's comments.
Thank you, Mr. Spivak. Would the parties like to introduce themselves and make any reply comments?
Surely, Your Honor. John Dodge, appearing on behalf of Washington Gas, and I'm happy to make my comments now or turn it over for further introductions first.
Please.
Your Honor, Lisa Gast with the law firm Duncan Weinberg, Genzer and Pembroke on behalf of the State of Maryland, Office of the Attorney General on behalf of the University of Maryland, College Park.
Thank you.
Good morning. Jason Gray, also of the law firm Duncan Weinberg.
Thank you. Mr. Dodge.
Thank you, Mr. Chairman. Good morning, everyone. Washington Gas is concerned with staff's interpretation of our rate schedule number 4 because we do not believe their analysis comports with Maryland law. Under Maryland law, tariffs have the force of law. They are akin to statutes, and they are to be construed using traditional rules of statutory construction. When interpreting a tariff, its terms must be taken in the sense in which they are generally used and accepted, and it must be construed in accordance with the meaning of the words used. That is the Maryland jurisprudence on tariff construction. If you turn to staff's comments at page 3, you will see that they have reproduced the key part of rate schedule number 4, which provides that customers which fail to interrupt, as you've heard, are subject to a $3 per therm penalty charge, and I stress the word charge, and an unauthorized consumption of gas charge rate, and I stress the word rate. Those are the literal words of the tariff. That gas charge rate is equal to the highest actual price paid during an interruption from a source from which actual purchases were made during the period of noncompliance, multiplied by a factor of 1.5. The literal words used in rate schedule number 4 provide that customers are subject to a penalty charge and a gas charge rate. The penalty charge is $3 per therm. The gas charge rate is determined by a formula, the highest actual price paid for gas multiplied by 1.5. Under tariff construction rules, again, looking at the words of the tariff and their common meaning, we can see that the penalty charge is different from the gas charge rate. The gas charge rate is a formula approved by the Commission. It includes the actual cost of gas and a multiplier. The rate could have been tied to the price of milk, or the cost of a Bitcoin, or the LIBOR index. It was not. Here it is tied to the actual cost of gas plus a multiplier. That is how the actual cost of gas is defined. It is not defined as a penalty. It is defined as a rate. Staff's interpretation, which I believe the university shares, is that the multiplier is a penalty. But to reach that conclusion, and in contravention of tariff construction rules, one would need to read something into the cost of gas definition that does not appear there. One would need to add words to the end of that subsection so that it would read something along the lines of multiplied by a factor of 1.5, which multiplier is a penalty. Under Maryland law, one cannot read words into a tariff that are not there. Staff's recommendation that Washington Gas clarify its tariff proves this point. If more words are needed to show that the multiplier is a penalty, that means it is not under the current tariff language. Staff and the university also implied that the Commission's approval of Rate Schedule 4 was premised on their interpretation of the tariff. Staff goes so far as to argue that its comments before the Commission back in 2015, when Rate Schedule 4 was revised and approved, constitutes precedent, which must be followed here. Of course, no single party's interpretation of a tariff or a statute constitutes precedent. The precedent that must be followed here is the tariff itself. And of course, the Commission will set some more precedent, probably this morning. One final note. Washington Gas remains neutral on whether the penalty waiver request should be granted, but I would like to remind the Commission that since the university, which is one of our largest and most valued customers and one of our best paying customers, they've already paid, we're going to have to claw back that money from customers. They've been paying a lower cost of gas charge that reflects the penalty and multiplier payment, and we will have to reconcile, if the Commission decides to grant the waiver, we will have to reconcile that cost of gas and essentially debit ratepayers' cost of gas going forward through our actual cost of gas filing. Doesn't come out of our shareholders' pockets, it is taken back from our customers. With that, I'm happy to answer any questions.
Why don't we hear from University of Maryland's counsel first, and then we'll have some questions for everybody, I assume. Mr. Gray?
Yes, thank you, Your Honor. Quite succinctly, the university agrees with the staff's interpretation of the tariff. We think it's the only reasonable interpretation based on the plain language of the tariff, and when read in context with the requests for clarification that the university has been asking for on this precise issue since 2014, we were pleased to see the clarifications. When we first had an issue in 2014, we asked for this very clarification of what is a penalty, what is a charge, and what is a penalty charge. We were pleased with the improvements made in the tariff in 2015, particularly with respect to the waiver, but also with respect to staff's interpretation, clarifying what was a penalty and what was a penalty charge. We still had some questions, but we viewed staff's position as a development that was in the right direction. And we continue to believe that the cost of gas is exactly that, is the actual cost of gas. The 1.5 multiplier does not need additional language to clarify that it's a penalty. It is by definition a penalty, and anything in addition to the cost of gas, such as the 1.5 multiplier, is not the actual cost of gas. So staff's interpretation of the tariff is consistent with how the university believes the tariff is written and should be applied.
Would you agree with Mr. Dodge that the 1.5 multiplier is a rate as well?
I think it is a rate, and I don't necessarily I believe a penalty could be a rate, a charge could be a rate, and I think that that element of the charge is the penalty component of the rate. So I think there's certainly room for overlap there, and this is an area where there is that overlap.
And to be clear, the University of Maryland has paid this invoice in full?
Yes, that's clear.
Right. Didn't help Washington Gas with the fact that the line item here said interruption penalty. Not sure that belies any point here. But Mr. Dodge, any multiplier, wouldn't you agree that any multiplier has a punitive component to it in this respect?
I acknowledge that the person on the receiving end of the multiplier would interpret it that way. My recollection from casual conversations around the revision back in 2015 was this multiplier was intended for two purposes. Number one, it was intended to provide an additional disincentive for those who were thinking about interrupting, that they would pay more for the actual cost of gas than otherwise. Second, it is, and here's where my math skills fail me, but it was also considered part of a disincentive against arbitrage by suppliers and their customers to go out and try to game the system during the most expensive periods of gas purchase. So it's a disincentive. Perhaps it's a matter of semantics. I do not consider it, the company does not consider it a penalty.
Well, there's no question that any unauthorized takes of the commodity during a period of stress, particularly for IT customers, is a serious action. When the University of Maryland became aware that on these dates and questions that they would need to discontinue service or face any penalties, did the university proactively notify Washington Gas that it would not, that it would be taking gas?
I would have to go back and check. Sitting here today, I don't recall.
Does Washington Gas have a response?
We were not notified, but no interruptible customer is required to notify us under the tariff. We would know from the reading of the meter the next time we read the meter.
For the university, you're asking for a waiver of the entire $1.6 million, is that correct?
That's correct. The original petition was for the entire amount in dispute. We understand that some component of the entire amount in dispute is a commodity component.
Exactly.
We were not necessarily clear as to what the interpretation was between a penalty and a charge. So based on the clarifications that we asked for in 2015, we asked for a waiver of the entire amount. We understand staff's rationale and the basis for that rationale, and do not oppose the staff's recommendation for the penalty component of the total amount.
Right, the university took over 50,000 therms of commodity, and at least in your application, you're saying you don't want to pay for any of that.
We have a footnote in our petition saying presumably there's an element of that 1.6 million that's the cost of gas. We don't know what it is.
Presumably, I mean, there is.
Certainly, fair enough, yes. So we did not know exactly what it was. Based on the uncertainty as to whether a penalty charge is waivable or only the penalty component, we asked for the entire amount, but certainly understand the basis for staff's recommendation of the $738,000 and what's been defined as penalties.
Looking at communications between the utility and the university, it appears that actually Mr. Dodge contacted Mr. Gray on December the 18th via email eliciting a response. Mr. Gray, did you respond to that email by Mr. Dodge?
I did not, and the university did not respond to that email. We understood the email to be a rejection of the request for a hybrid tariff with a firm component and an interruptible component, as the goal was to achieve, at least begin negotiation of a new contract. We did not see that the door was left open to do that, so there was no further communication.
I think the door was left wide open. In fact, I think Mr. Dodge asked for some dates to meet with the University of Maryland. That's an unfortunate lapse in communication, I would say. Mr. Dodge, what does Washington Gas do with the penalty revenue that it collects?
According to rate schedule number 4, we pass through either a credit or debit to ratepayers for both the unauthorized cost of gas and the penalties. And it initially goes through what's called our purchased gas charge, and then any reconciliation, for example, were the commission to rule in the university's favor, would be made during our actual cost of gas adjustment filing, which I believe is made on or near November 1st. So it is reconciled to reflect the payment of the penalty and the cost of gas, and were that to be reversed, we would reconcile in the other direction.
Okay. So under no circumstances is the collection of penalty revenue a profit center for the utility?
That's correct. We don't make any money on the sale of gas to begin with, and we don't make any money assessing penalties and passing them through to ratepayers.
Thank you. Taking a look at the commodity charge, somewhere around $15 multiplied by 1.5, is that correct?
That was the highest price per therm paid during, I believe it was on January 5th, and we supplied staff and the university proof of that in the form of our interstate pipeline invoice, the cover of the invoice and the relevant page showing that tranche of gas, which was highest. We actually priced the overall use of gas using what is called the weighted average cost of gas. So in this case, that would mean that the university would pay always the highest average cost of gas. Otherwise, ratepayers would subsidize their unauthorized usage, but it doesn't mean that they always pay the highest increment. So it's not that they pay $15 if we only bought 100 therms. They would pay a proportion, their relative proportion of that.
And that rate, the weighted average cost of gas, is that calculated once per day?
I believe it's, I'll have to check if I may.
Okay.
We buy the gas on a daily basis, but we make the calculation on a monthly basis.
So it would be $15 for both days here, January 5th and 6th?
I believe the highest price was only, of $15 was only on January 5th. So we would use whatever the highest price was on January 6th, and I don't recall what that was.
Getting back to the communications, and it looks like through the emails it was mostly you and Mr. Gray, if I'm not mistaken, seeking this hybrid arrangement, which is something that I'm not terribly familiar with. Did the university ever seek to just become a FT customer of Washington Gas?
I don't believe so. The service agreement initiated in 2001, and at that time it was a one-year deal it was a hybrid deal, similar to what we were asking for now, where a portion of the volumes were taken firm, a portion were taken interruptible. When that contract expired, it was extended for a period of 10 years under the same terms. That 10-year period ended at the end of 2012, I believe, and there were discussions at that time for a further extension. Those discussions did not result in another contract, so under the Evergreen provision, the university was only an interruptible supplier. And in the intervening period, we've had some discussions with Washington Gas about a new interruptible contract or a new firm interruptible hybrid, but to date we do not have an existing contract. There's only services only being taken under the Evergreen provision of Rate Schedule 4.
Are you eligible to receive an FT contract with Washington Gas right now?
I believe we are eligible. I don't necessarily see a distinction between taking some service as firm and some as interruptible, and being firm only as, in terms of process, being any different than what we tried to initiate in June. It would really just be a question of the volumes that are taken on a firm basis. My understanding, since there was doubt as to whether a lower amount of volumes could be taken on a firm basis, whether the full load could be switched over, and the university has not received any cost estimate of what the facilities would need to be, what facilities would need to be put in place in order to meet either a portion of the load on a firm basis or all of it.
Is Washington Gas available or able to provide the university with a firm contract if they so desired?
We are not. Let me answer your prior question from our perspective. The university or any interruptible customer is always eligible to ask to switch to firm service. That will, and they did not in this case. They asked for a hybrid contract. A request for firm service would initiate a network analysis on our part whether we could meet that firm load request. I can tell you right now that as our facilities stand in that area of our system, we cannot meet their request for firm service. And that was communicated, at least informally, to both the university and its outside engineering consultants. We are talking, can we provide an estimate? If directed by the commission or formally requested by the university, we would endeavor to do that. I would say back of the envelope, we're talking many tens of millions of dollars, because this implies transmission facilities. This is our largest single customer in Maryland. It's on an older, capacity-constrained part of our system, and we would have to do significant upgrades. We have long-term plans to do that over the next 5 to 10 year planning horizon, but we certainly can't turn that around within the course of a heating season or anything like that. We're talking about significant construction, scoping, permitting, all of the things that go into a major construction project.
So the university has always been an interruptible customer?
That precedes my tenure, but I think they've always been, since 2001, they've been at least a part interruptible customer.
Mr. Chairman, if I might just elaborate on one point here. What the university is asking for here is not actually firm service as it would be understood for regular firm service customers. They're asking for a special contract. They've had one in the past and presumably could negotiate another one, but it's not really what we would think of as firm service at firm service rates.
Right. No, thank you, Mr. Spivak. And at this point, there's no ongoing negotiations in an attempt to get a hybrid contract for the University of Maryland?
That's correct.
Okay.
That's correct. And just to clarify, I think the mechanism, whether it's a hybrid contract or two contracts, I don't think the university has a preference as to how it's structured or what it is called. The concept, we use the hybrid structure because that is what was used in the past, but the intent, regardless of how it's structured, would be to take some volumes on a firm basis and some on a deliverable and an interruptible deliverable basis.
So you could find yourself in the same situation as you do today, but on a smaller scale.
The intent at the time, and there have been some changes in strategy and then also with assets at the university, so I'm not exactly sure where things stand, but the intent at the time was to take enough volumes on a firm basis where they could shift load from the university, and during an interruption event, they could just basically reduce load and meet their heating demands with the firm capacity and firm deliveries.
Just to be clear, in this case, did the university reduce any of its load? The Severn building, it looked like, was one that was perhaps...
Yes, and that is something that we noted in our petition. The university has 2 accounts. It fully complied at one account, the Severn building. The issue here was with the CHP account, the Combined Heat and Power Facility, and it did not reduce load on either day. So we're only dealing with one of the 2 accounts.
Okay, so the university knowingly, with eyes wide open, recognized that it would be subject to these penalties. This bill was not a surprise when you received it.
No, we did not know the price of gas. We didn't know the extent of the penalties, but the university was certainly aware of the tariff changes that were in place in 2015, and that it would be subject to the $3 per therm penalty, the unauthorized use of gas charge and penalty, and pilot gas charges.
Thank you. Colleagues.
Let's see, the chairman's question has been pretty thorough. Let me just, a couple of follow-ups. WGL, Mr. Dodge, do you do annual interruption tests? Is that something that's routine, or is it just something at the company's option?
If I can rephrase the question a little bit, we have tariff authority to do random checks of interruptible customers.
Okay.
Most interruptible customers have an obligation under the tariff to do their own interruption test to make sure that their backup systems are working. So those are slightly different things than you asked, but that's what tariff authority we have.
Okay, so, but it's not a routine of WGL. I guess where I'm going here is if these tests are done and the customer fails, at what point, and going back to your answer a moment ago, they can then request a firm tariff, a firm commitment, or is that just really up to that's an option of the company to either say yes or discontinue them as a customer if in fact they have failed that test?
I think it's more toward the latter, Your Honor.
That's the only option then.
Again, an interruptible customer is always eligible to ask to transition to firm service, and we have to do our network analysis to see if we can accommodate that, no matter what the load is. If it's a hybrid, firm, interruptible, or full firm, we have to do the same, essentially the same network analysis. If we have a habitual non-interrupter and they continually fail their own interruption tests, we have the option under the tariff to discontinue serving them.
Okay. So that, but in the case of University of Maryland, it sounds like their only option would have been, given that there was no hybrid offered to them at their request, would be just discontinue. So they were kind of in a bind then at this point. Either no gas or a penalty gas.
I just sent my daughter off to college, and had she gone to the University of Maryland, I would be a parent saying, do not interrupt, don't freeze her out of her dorm room, that's for sure. I understand the constraints on both parties here. We have to hew to the tariff authority as we understand it. And in this case, we delivered the gas. We went out to the market to buy very expensive gas to replace what the university was paying. We passed it through the formula. I don't think anybody's disputed our math in the calculation of the invoice. So the question before you is what constitutes a penalty under the tariff?
Okay. And then on that point, so if the customer violates the interruptible service agreement, that automatically moves them into a different category, right? They're no longer paying the tariff that they've contracted for. They're now into, in a sense, the violator's penalty.
That's right.
Couldn't we look at that as entirely a penalty then?
I don't think so, because number one, as I've said, how the tariff defines the unauthorized gas charge and the rate associated with that. And the Commission has already ruled, in fact, in case number 9398, when Public Utility Law Judge McGowan summarized it brilliantly, I thought, gas is not free. So there is at least some component of what we bill that is the commodity charge, and we're here today to try to sort out what that is the cost of gas. It is not free. And again, to reiterate, we don't make any money selling gas. We make money delivering gas. And any penalty, any unauthorized cost of gas, or the rate for that is flowed through to customers. We're a neutral entity in all of that.
Fair enough. Can I ask the same question of staff? When we look at, when the violation takes place, obviously the customer is placed in a different category. Could we look at that new category as an entirely as a penalty, if you will, category? Obviously, there is a true commodity cost in there, but anything above that commodity cost, isn't that, in fact, a penalty because of the violation?
Well, I think that's exactly what we're saying, Commissioner, is that anything above the actual commodity cost that was paid is a penalty. And that said, I had a question. What Counsel for Washington Gas said about the way they calculate the price of gas for this customer, it actually seems to be not quite in compliance with the tariff, because the tariff states that the price component that's paid here is the highest actual price paid during the interruption, and they seem to, and what Counsel seems to have said is that, in fact, their calculation uses an average price of gas during the interruption, not the highest price paid.
If I said that, I apologize. I did not mean to. I think what I said was we use a weighted average cost of gas formula that the Commission approved in case number 9398, by the way. And, for example, if there were 100 therms purchased on a January 5th at $15 a therm, we bill that entire tranche to the University of Maryland, and then we average the rest of the gas that they use. So they're always paying for the highest tranche of gas that they use, but for their lack of interrupting, we wouldn't have had to buy that. So with all due respect to Mr. Spivak, my dear friend, we do not average. We use a weighted average to make sure that an interrupting customer pays for the highest tranche of gas that we buy.
Okay.
Mr. Dodge, all right, so weighted average cost of gas, $15. The component, whether we call it a penalty or rate component, above and beyond that is the 50%, so it's $7.50. When the utility receives that $7.50, how does it treat it? Does it treat it similar to the overrun penalty of $3?
From a ratepayer perspective and a cost of gas perspective, that's exactly right. We credit that $7.50 to the cost of gas that we charge to ratepayers. So, in essence, the ratepayers as a body, firm ratepayers in Maryland, will pay less on their bill for the cost of gas because we're offsetting it with, in your example, $7.50.
Okay, and so it's just so what I've heard from staff then is we could look at this and say once the violation takes place, we're now in a penalty tariff at that point, and look at it in a in a holistic way that way, that all those costs that are above the actual commodity price itself is a penalty. Is that an appropriate way of characterizing what you just said?
The second part of what you said, Commissioner, I think certainly fits the first part. I mean, this is part of the broader interruptible service tariff. So, I mean, the specific provision that applies, that is a penalty provision, yes.
Okay, and then finally, do we have discretion as a commission when we look at the waiver to grant the entire 100% of the waiver or a percentage of that waiver? Is that something that the commission can look at and make a determination based on the facts, or is it all or nothing?
I think the commission is pretty much bound by the tariff itself, so it really should be all or nothing with respect to the penalty.
The penalty. So once we determine if there's we're trying to determine, I guess, what the penalty or what the bounds of the penalty are.
Right.
So within that, does the commission have some discretion as to 100% of the penalty or of the waiver, or can we waive 100% of the penalty or a percentage of that penalty?
Again, I would say the commission has the discretion to determine in its interpretation of the tariff. So in that sense, in determining how much the penalty is, the commission does have discretion, but, and again, this is a waiver provision, so you can perhaps argue that the extent of the waiver is within the commission's discretion, the extent of the waiver granted, but the tariff itself is otherwise binding.
If you say we can argue, are you saying that
I think that's
staff
a
would
le-
argue
that's-
that?
I think that's a legitimate argument. I would actually want to look more into the law behind it, but I think with respect to a waiver, the extent of the waiver that is granted is within the commission's discretion.
Okay, great. Thank you.
Yeah, thank you. There were quite a few good questions already. Covered several of the topics I had questions about, but I'd like to confirm with both the university and the company that you agree with the analysis of the two criteria for a waiver in the commission staff's comments. They're listed on page 8, where they've laid out the question as to whether or not there's whether or not the failure to interrupt was beyond the university's control. And secondly, whether the university demonstrated a good faith effort. Just for you, Mr. Dodge, the staff notes that the university had passed a Washington Gas readiness certification, or met those requirements in 2017. But it appears as though, from at least the way the dates are laid out, that there was a problem with the nozzle before the time period for that certification. So I just wanted to make sure that both parties are comfortable with that layout of facts that's in the staff report.
To answer your first question first, we do agree that there is a two-part conjunctive test embedded in the tariff for assessment of a waiver request. Second, I don't recall off the top of my head when the readiness certification was accomplished. I do know, I think within a couple of days, around August 15th or 17th, was when the university discovered its catastrophic nozzle failure and it would not be able to interrupt. So I can't really speak to the readiness question.
As to your first question, Your Honor, yes, we agree with staff's analysis. We think that element of the tariff is fairly clear as to what the two elements are, and those were the two elements we addressed in the waiver petition. As to the second question, it may be a little bit beyond what I can speak to technically, but I understand that there may be different components of the readiness test. For example, the university has auxiliary boilers that can burn liquid fuel, and I'm not sure whether the readiness test determined whether those auxiliary boilers could burn liquid fuel, whether there actually was liquid fuel. I think that might have been the limit of the most recent test in 2017, and the auxiliary boilers were able to switch over to the liquid fuel, whereas the issue here was with the combustion turbine and not the auxiliary boilers that are operated in conjunction at the CHP facility. And I also know we responded to a staff data request on this point that the university has since changed its strategy of how it deploys the CHP, or how it will deploy the CHP facility in a future interruption, in addition to procuring a new combustion turbine. So it has to do with the ability to generate electricity at the same time you are producing steam to meet the university's needs. So the university will no longer be running the combustion turbines during an interruption to produce electricity. So that aspect of the test from 2017, whether the auxiliary boilers can burn liquid fuel, would be sufficient to meet the university's needs.
Okay. Are you able to explain why the university waited until after hearing that the hybrid solution wasn't going to go forward, that the university at that point decided to order the temporary boiler, as opposed to doing it when the nozzle was, when you first determined that the nozzle was no longer
Certainly. And we also responded to a data request on that point as well. To summarize, before the university learned of the nozzle failure, we had reached out to Washington Gas about the prospect of a tariff with a firm delivery component. That was in July, about a month before the nozzle failure. It took a few weeks after the nozzle failure to kind of do a study and determine what the issue was, to talk with the manufacturer and get estimates on how long they would think it would take to to have a corrective solution put in place to the extent one could be. That's where the university, about a couple weeks, 2 to 3 weeks after the event, got the estimate of a 53-week lead time to the extent the nozzle could even be repaired. And there were some questions about whether it could be, and some technical questions on laser printing the new nozzle and how long that would take. So the university really went down a few parallel paths at that point. They were hopeful that they would be able to enter into a new agreement with a firm component, and hopeful that that would resolve the issue. As time dragged on, the university became less hopeful, but still held out hope. And once we received the notice from Washington Gas that it could not provide firm service at this time, the university ordered the auxiliary boiler that same day that the notice was received.
Thank you.
Thank you. This is a difficult case. The fact that we're having the largest customer of the utility here, there were some obvious issues in a failure to communicate. The university should have let Washington Gas, whether it was obligated or not, know as soon as the nozzle failure occurred, even though it was during a blue sky event in August. The university should have, even though it's not required, notified Washington Gas that on the coldest day it was going to proceed to violate the terms of at contract and take unauthorized quantities of gas, which could have put the system at risk in terms of reliability. But at the same time, I recognize now that the university doesn't have any option currently to become a firm transportation customer of the utility. With respect to the component of the unauthorized consumption of gas charges recharacterized on the most recent updated bill, I do believe anything above the $15 in this case would be considered a penalty. I also agree with Mr. Dodge that it is a rate on file. But the collection of that additional amount, $7.50 in this case, as Mr. Dodge said, is treated no differently than the overrun penalty. Taking a look at all the evidence in this case, and recognizing that the University of Maryland is not entitled to receive $1.6 million in a refund, I would agree with staff's analysis that the overrun penalty is waivable, along with the portion of the unauthorized consumption of gas. Anything above a factor of 1.0 would be waivable. In my opinion, the university has shown good cause, but just by the skin of its teeth, to receive a waiver. For these reasons, I would agree with staff counsel's recommendation to provide a waiver of $738,394.38. That is my position. Commissioner Richard?
I do agree with what you've stated. I think that the university did demonstrate a good faith effort to comply with the interruption notice, and given their only other option was to be completely shut off, I think it would be unreasonable to have expected the university to cease operations or at least to significantly scale back. So I think we definitely can use the waiver authority, and I do agree with staff's interpretation of what the penalty is, and would also agree with their calculation.
Commissioner Linton.
Yes, Mr. Chairman. I also agree that the company has, the university has demonstrated the need to receive the waiver. I would also agree that it is a very thin line that they've met in this particular case. To me, at least a good faith effort would also include communication at a time there's a potential, or at least a perceived real potential, that you'd be unable to operate under the terms of the tariff that you've agreed to receive service under. I didn't do all of the math, but I would agree with your numbers that $738,000 is and $394 is the requested amount that could be waived. As to, I guess that does address the majority of the issues. It doesn't get to the question of the interpretation that staff has presented. as part of their report. And I'm not entirely sure where I'm going to go on that yet.
I'm sorry, Commissioner Linton, what was the last part you said?
The portion of their recommended motion regarding the interpretation of the rate schedule.
I do not believe we need to reach that today.
I agree.
Okay.
Just so I understand, so collectively, we're not ready to go ahead and just memorialize staff's interpretation about what a penalty is?
That's right.
Okay, all right, I guess I'm in the minority here on that one then. I don't think we need to, obviously, we're not going to change any of the tariffs, but, okay.
So we are ruling on the request for the waiver. Is there a motion?
Yes, Mr. Chairman, I move that we grant the requested waiver for $738,394.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved. The waiver is granted for the amount stated. Thank you.
Thank you, Commissioners.
Mr. Dodge, why don't you have
I'll have a seat.
a seat?
Item number 12 is Americana Center Condominium, Inc., filed on April 6, 2018, a request for a waiver of the penalty provisions pursuant to Washington Gas Light Company's gas tariff, Section 2 of interruptible delivery service under rate schedule number 4.
Ms. Garofalo, why don't you take a seat as well? And do we have counsel for Americana present? If you could approach and take a seat at the table. Thank you. Ms. Garofalo.
Good morning again, Mr. Chairman, Commissioners. Americana Center Condominium, Inc. is requesting a waiver of penalty provisions pursuant to Washington Gas Company's gas tariff, Section 2 of interruptible delivery service under rate schedule number 4. This is somewhat similar to what you've just heard. ACC failed to fully comply with the distribution system interruption day event, which triggered the penalties for failure to interrupt. In staff's comments, we put forth the same interpretation of the law as the preceding item. But as to the facts of this situation, on January 4th, 2018, WGL sent a notice of interruption to Schedule 4 customers indicating that an interruption day was scheduled for January 5th through 7th of 2018. ACC misunderstood the nature of the interruption notice and as a result complied only partially during the interruption event. Though ACC fully complied on January 6th through 7th of 2018, it failed to switch to an alternate fuel on January 5th, 2018. Consequently, the customer used approximately 2,258 therms of unauthorized natural gas during the interruption period. During the single day of noncompliance, ACC accrued $57,919.79 in charges and penalties on its January gas bill. ACC failed to interrupt on January 5th solely due to a communication error occurring between ACC's management office and its engineering staff. This is confirmed by information provided by WGL in discovery and discussed in staff's comments, including a return receipt signed by ACC, which shows WGL obtained updated contact information between the 2017-2018 heating season. The fact that ACC incurred no penalties or charges during the remainder of the interruption event indicates that the failure to comply on the first day of the interruption was not due to a mechanical failure or events beyond ACC's control. ACC did not seek clarification or additional information regarding the scheduled interruption event from WGL after receiving notice on January 4, 2018, and WGL does have significant resources available which can be used if there's some confusion about this. Thus, staff believes a good faith effort to verify the notice was not established and that ACC failed to demonstrate a good faith effort to comply with the interruption notice, and therefore staff recommends that the Commission deny the penalty waiver.
Thank you, Ms. Garofalo. We'd like to take appearances from the other parties at the table.
Thank you, Mr. Chairman. John Dodge, appearing on behalf of Washington Gas.
Thank you.
John Becker, member of the Board of Directors of Americana Center Condominium.
Mr. Becker, thank you.
Janet Wilson, I'm president of the Americana Center Board of Directors.
Ms. Wilson?
Yes.
Thank you. Mr. Becker, Ms. Wilson, would you like to respond to what you just heard from the Commission's staff counsel?
Yes. Thank you. Again, my name is Janet Wilson. I'm president of the Americana Center Board of Directors, and I'm accompanied by John Becker, also another volunteer member of our Board of Directors. Our condominium is located in Rockville, Maryland, and I'm here today to ask the Commission to waive all or a portion of the interruption penalty assessed by Washington Gas for the one-day failure to interrupt service. We understand that a robocall was placed to our condominium on January 4th, and we confirm that we received that call. However, that was the only notice that we received, and it was construed by our staff to be in effect on January 6th, and we complied. Washington Gas indicates that several other email notices and faxes were also sent over the ensuing days, but we have no record of receiving them. It was not until after the interruption, when reviewing the resulting invoices, that we determined that the various emails assigned to our condominium by Washington Gas had not been updated, and they go back to 2015. Staff noticed that they have a certified receipt. We didn't receive a copy of that. I'm not aware of. We have since proactively updated all of our email and contact information with Washington Gas. Thus, as borne out in the June responses filed by Washington Gas to staff's inquiries, the emails and other notices that were sent to stale addresses. Staff cites the language in rate schedule number 4 that Washington Gas was required to give not less than 2 hours notice of the pending interruption. But I'd like to point out that rate schedule number 4 also provides on page 33 that, quote, each year the company shall request and the customer shall provide the company by October 1st the name, title, address, telephone, facsimile number, and email address of at least 2 individuals who are designated by the customer to receive notices of interruption. We have no record of receiving such requests or notices, we believe, going back to 2015. We understand and appreciate why the interruptible service tariffs are in place. We understand the importance of compliance, and this is a first event for us. We may have misconstrued the robocall, but we suggest that Washington Gas also bears some responsibility to its customers to ensure that it does everything it can to ensure compliance and notice, considering the severe penalties, which by your staff's calculations are $23,706 for one single day of interrupt. Had Washington Gas notified us as required by the tariff, viable contact information would have been provided and the interruption complied with, as multiple checks would have been in place. In closing, I'd just like to put this a little bit into context. We are not a commercial entity, we're a residential community. And we're not a wealthy community. And many of our members are on fixed incomes. The impact of the one-day penalty is severe on our budget, and it's coming directly out of the pockets of our residents. The employee responsible for checking the voicemail box and communicating the interruption is no longer employed by us. We've proactively updated all of our contact information with Washington Gas. We have acted to ensure to the best of our ability that this does not happen again. And we respectfully ask the Commission to grant some relief, given that we feel there was fault to share. Thank you for your time.
Thank you, Ms. Wilson. Mr. Dodge?
Yeah, 1 or 2 points of clarification. First, we remain neutral on the grant of the waiver as we were in the university circumstance. Second, I will not burden the Commission with my interpretation of the tariff anymore.
Thank you.
Third, I think there was an accidental incident here, and I'd like to explain what I think personally may have happened. Each year we send out a preparedness packet, if you will, to all of our interruptible customers. We send that out before each heating season. That packet asks each interruptible customer to update or provide us current information. That is tied to the return receipt that we provided in Discovery to staff. That's what that was for. It was our annual regular packet that we send out, not just to the condominium, but to all interruptible customers. And in that is a request to please update your information.
Does the condo association dispute that you received this packet?
We have not received any.
Yes, we do dispute it. We don't have any record of it.
Mr. Dodge, do you have a return receipt signed by an ACC representative dated September 19th, 2017?
We provided that to staff in Discovery.
Okay.
We're printing it out right now.
Okay, we'll get a copy. We'll share that with the board members. I'm sorry to interrupt.
No problem. I just reiterate that I believe the association is in good standing vis-a-vis their payments. So just as in the university circumstance, we would be debiting the firm body of ratepayers for any waiver relief granted here today.
Thank you. Ms. Wilson or Mr. Becker, how many units do you have in your building?
We have 425. 2 of those are owned by the association.
Is it just one building?
No, we have 22 buildings. We have 2 high-rise buildings, we have 20 garden-style buildings, and then we have 12 townhomes. It was built in 1970.
And is this entire complex master metered?
Yes. Sorry.
It appears that this is the first time that
Yeah.
you as a customer of Washington Gas have been asked to terminate service because of a...
To my knowledge, yes.
Okay. And how long have you been on this service rate schedule?
Oh, gosh. I don't know.
At least a decade or more.
What is your contingency plan since you're serving residents? It's a residential customer here. In a situation where Washington Gas directs customers to either stop taking service or face a penalty such as you faced. I imagine people are going to be getting cold in their...
Oh, okay. We have an alternate fuel source here. It's a fuel oil, which it's a dual fuel boiler system, which heats which provides the mechanical water and heating.
And how often is that system used?
Maybe once every 2 or 3 years. I mean, depending on, the North Polar Vortex and all kind of things like that. If you're looking for a history kind of thing, I'd say once or twice in 5 years.
Walk us through how your front office operations works and how this fell between the cracks when you received a robocall from Washington Gas. An employee or perhaps another volunteer answered the phone.
It was an employee, and my understanding, the robocall went to a voicemail system, and the associate that monitors that phone was out that day. When she came back the next day, she got the call immediately, shared the information with our maintenance staff, but again, we were a day late.
Margaret, can we have copies or can we see the return receipt? If you just have one, we could share.
Could you give those to the chairman, because I can't reach that far. Just give me one minute.
Thank you, Juan. Ms. Wilson, do you recognize the name and signature of who signed this return receipt?
Yes, I do.
Okay. Who is this individual?
The name is Rena Vora, and she was our administrative assistant. Was.
Is she the same individual that received the phone call?
Yes, sir.
To your knowledge, do you know what Ms. Volma did with the information that she signed for here?
I do not, because our office was unable to produce a copy of this.
Again, this is the first time we're seeing this.
Yes.
Does the condo association have any outstanding data requests of staff for the utility?
No.
Okay.
No, and in fact, the penalties, we have proceeded to pay the penalties while we were in this process of requesting the waiver, just to stay as customers in good standing.
So your account balance currently is zero?
Yes, sir. It's current.
Commissioners Richard or Linton?
I think you've asked questions I can think of asking as far as this. You've already answered the question. This is a first-time violation, if you will,
Yes, sir.
of this. Okay. No additional questions.
Just one for Washington Gas. As part of your annual review requirement, what was the process you used for this particular customer? Was there actual on-site visit, or was it just a packet mail? Was there any other step taken?
I don't know of any on-site visit. We do a batch mailing of our preparedness and reminder packets to all interruptible customers.
So as part of the packet, is there any other information that the company, or excuse me, the customer is required to report back to the company, or is it just the update information? Or is
I believe under the tariff they have to maintain an analog telephone line on site. So there are some sort of one-off types of information that we keep track of. We also have an annual interruptible customer forum at our Springfield, Virginia headquarters, and I believe that invitation is extended across our system to all interruptible customers, and it essentially covers what's in the preparedness packet.
So as part of sending out these packets, do you normally have some response, or do you expect a certain amount of response from the customers, or do you send some packets out and you never hear anything?
That I do not know.
All right, thank you.
Actually, may I just ask a couple of questions of WGL, Mr. Dodge? How many, do you know off the top of your head, or do you have the information, how many interruptible customers do you have?
187 in Maryland, I believe.
So 180.
I should say 187-ish.
Okay, so it's not a huge. We're not talking thousands. Okay.
Correct.
And as far as the and again this annual interruption test, so this is not something that you. Maybe you said you do them randomly. How many random tests and how many customers did you contact this year and last year? On average, how many of these random tests do you do?
I don't know the specifics, but I do know that we tend to audit or visit habitual offenders first, and we have capacity to do that, and then we do randomize our site visits and checks after that.
Okay, so but I mean, of the 187, do you try to get 20 of them, 50 of them? What scale?
Subject to check, I believe we aim to get between 10 and 20% every year that we check.
All right, so there is.
That's from case number 9398, and I may be off base on that.
Okay. All right, and as far as the ACC here, did they get any opportunity in the last 10 years where they randomly selected, to your knowledge, or to?
Not to my knowledge, but it's because I don't know. I
okay.
just don't know.
All right. And as far as communications, this packet that you send out every year, certified mail, is that pretty much the extent of how you reach out to the 187 interruptible customers in your system?
For the winter preparedness and reminders about penalties, yes, that's one of the primary outreach tools that we have. We also, as I said, we have a forum every year. Our inspectors are available for questions. Of course, people can call us if they have any questions.
Okay.
Many of our interruptible customers depend on their suppliers to manage the relationship. So we have a pretty tight relationship with the competitive suppliers who serve these interruptible customers.
Okay, and not having seen this packet, or I don't know if it's necessary for us to see it. I mean, doesn't it contain information about the consequences, the severity of the consequences, the financial consequences of violating the agreement?
It does.
It does have that information. Okay. All right, great, thank you.
You heard the case before us where we had a situation with a customer who knowingly violated the terms of their contract and took excess gas when they recognized that they would also be facing penalties. Here, I see the situation a bit differently. the condo association is not a habitual offender. However, we do have evidence here that the condo association was properly notified. I note that it's actually 1 year ago today, so you should check your mailbox to see if there's another package in your mailbox. Mr. Becker, do you have something to say?
I have a couple of questions, whenever it's okay to do so. Well, first of all, I think on the certified letter receipt, return receipt, I guess it is, I don't see who it's from.
Are you disputing the
No, I'd
validity?
just like to
Okay.
have that. I mean,
All
that
right.
would be very helpful, but I don't see it on here.
Right.
And number two, as far as the notifications, I'm looking at the evidence we did receive, and I see some things sent to a Marcel D. Fortune. I don't know who that is, so I just was going to ask who are these people that... I see their phone calls made to Americana Center, but I see an email trail here also. I just wanted to find out who that
You're looking at information that we don't have before us.
If I might, Your Honor, as part of our discovery, we provided our internal email chain about this particular incident. Mr. Fortune is a Washington Gas employee, and we simply reproduced and provided everything that we had that pertained to this case.
Thank you, Mr. Dodge. So I see some distinctions here between this case and the one that we just had prior. Let me ask the representatives of the condo association. You're seeking a full waiver of $57,919. Is that still correct? Do you...
Well, that would be lovely, but my understanding is the penalty is closer to $23,700. I think my understanding from staff's looking at the documentation is that the remainder of the money is for actual gas consumed. Is that correct? Yes.
That was our position in the
So
buck sheet.
I think the penalty is closer to $23,700. Thank you.
Based on those numbers from staff, do you concur that the association would be responsible for the balance?
Oh, are you asking me?
Yes.
Yes. Yes, sir.
All right. Thank you. That was less clear in the earlier case. Like I said, this was a difficult decision for me, but my position is that I would find, in order to balance the equities, that the association would be entitled to a waiver for similar circumstances for good cause shown. Obviously, there was a problem in your office. You received notification that person is no longer with the condo association and has suffered those consequences. Therefore, I would support granting a waiver in the amount of $23,706.90, with the condo association being responsible for the balance of its unauthorized consumption of gas on this single day in January. Commissioner Richard.
Yes, I agree fully with the chairman, and for the same reason. I think since this is a first-time violation, and I do have some concerns about the communications that take place between the company and also in these annual interruption tests. It seems like that would be something we maybe ought to take a look at it and try to maybe make them a little more rigorous and maybe a little more thorough, because the consequences of failure to conform are pretty severe, as we can see with the distressed condo association here. So I agree and would concur with that amount, to $23,706.90.
Commissioner Linton.
Thank you, Mr. Chairman. I'd also agree with the recommendation as presented and with the comments that have been provided.
Thank you. Is there a motion?
Yes, Mr. Chairman. I did want to revisit, though, the staff interpretation. Is it still your position that we not include that in the motion, or?
No, I would please include that in the motion. I was misunderstood when we made the prior motion. I would not direct the utility to file revised tariff sheets, but I would like to accept staff's interpretation.
Okay. And Commissioner Linton, did you have any comment on changing the motion then to include the interpretation, acceptance of the interpretation?
Well, I mean, I think it's, as a practical matter, it's 2-to-1, even if I did. But I think that...
I know how that feels.
Yeah, but I think for now, at least, if it was, I can't say I'm entirely excited about it, but we'll go forward with it for now and see how it works out.
Okay, thank you. I am prepared to make a motion. For item number 12, I move we grant the requested waiver in the amount of $23,706.90, and we accept the staff's interpretation of the Washington Gas Light Company Rate Schedule Number 4 tariff in its comments dated September 12, 2018.
Is there a second?
Second.
All in favor?
Aye.
Aye.
Motion is approved. The condo association just saved $34,000. Thank you.
Thank you, and thank you to staff for your diligence.
The next item, Madam Secretary.
Next item is item 13, Clean Choice Energy Community LLC, filed on July 19, 2018, request for a waiver from operational deadline.
Good morning again. Annette Garofalo on behalf of Commission staff. Clean Choice Energy Community LLC, in partnership with One Energy Renewables, owner of OE Monarch Solar LLC, is seeking a waiver under COMAR 20-620104 of the operation deadline for completing its community solar energy generating system located in Prince George's County. The waiver requested is for an approximate 6-month period after the expiration of the 18-month period allowed under COMAR 20-620304C1. Clean Choice's project has remaining permitting work to be accomplished and is concerned that construction, which cannot begin until the permitting is complete, may be disrupted by inhospitable weather. With a 6-month extension from PEPCO, Clean Choice's project deadline will be extended to mid-February 2019. Staff recommends the Commission grant Clean Choice Energy Community LLC a waiver of COMAR 20-620304C until June 1, 2019, contingent upon Clean Choice's payment to Potomac Electric Power Company of the amount required under COMAR 20-620304C1 to retain its place in PEPCO's queue.
Thank you. Mr. Begelmans.
Good morning, Mr. Chairman, Commissioners. David Begelmans on behalf of Clean Choice Energy Community LLC and One Energy Renewables. I'd like to thank staff for reviewing our request. I know there's been many of these, and it's been a process working through them with staff, and we appreciate that. I think we are relatively close. As the Commission knows, we requested a 6-month extension. Staff has recommended an extension until June 1st, which is slightly over 3 months. And we've kind of crunched the data and looked at the feasibility from a construction standpoint and have determined that June 1st isn't workable and that July 7th is an appropriate date. And I'll walk through our reasoning on that.
July 7th or August 7th?
I'm sorry, July 7th.
July, okay.
Mr. Chairman. To summarize the delays faced by the project, first, the project faced a 100-day delay in the mandatory referral program review from Prince George's County, which is the discretionary review project for solar projects in Prince George's County. That was in part due to the influx of applications they received from many different projects, and then also a simultaneous process to develop new siting standards for solar projects in the county. So that led to a 100-day delay. So that process took 160 days when it should have taken about 60 days. After that, the project faced delays with stormwater permitting. They're actually still working through that process. I can provide a bit more clarity today than we could in our initial request. The hope had been to receive that approval by the end of September, but that slipped until November. So that's pushing the most feasible kind of start of construction until very early winter, which is problematic.
Mr. Begelmans, in your letter dated July 19th, you stated that you were waiting until mid-September to receive your erosion and sediment control permits and stormwater permits.
Correct.
Have you received them?
No, Your Honor. The approval slipped to November, so that's still in process.
November now. Okay. Ms. Garofalo, they wanted July 7th. You give them June 1st. Why did we shave off about 5 weeks?
Well, I know it seems like a tempest in a teapot, but we are trying to manage when these come in, we don't know very much about any of the projects except what we know in general we put in our comments. We are at least trying to keep everyone at June 1. I know it seems that 5 weeks doesn't make any difference, but our concern is that the next one will then come in and it will ask not for July 7th, but maybe it will be August 30th, and then it will be September 15th. And so we're just trying to keep some unity among the projects. I note that this is not in the Potomac Edison service territory, but it's in the PG County service territory. So it is warmer there. Obviously, the zoning problems are different with each one, but
Okay. Well,
that's the reason for June 1.
Okay. And I do see a lot of the other projects have expected operations dates on the first or the last day of the month, so some uniformity there. Thank you. Commissioner Richard or Linton?
No additional questions.
Okay. Commissioner Linton?
No
All right.
questions.
Obviously, we've seen a lot of these before, mostly coming out of your firm, Mr. Buellmans. I would say that in order to keep some uniformity on all the dates starting on the 1st, I would suggest that we extend it through July 1st. That only takes 6 days off your clock. Hopefully, that'll be enough
I think that's
motivation.
acceptable, Your Honor.
Okay, that's good to hear. In that case, is there a motion?
Yes, Mr. Chairman, I'd move that we grant the company's request for a waiver of COMAR 20.62.03.04C until July 1st, 2019, contingent upon the company's payment to Potomac Electric Power Company of the amount requirement under COMAR 20.62.03.04C1 to retain its place in PEPCO's queue.
Thank you. Is there a second?
Second.
All in favor?
Aye.
The motion is approved. We're going to take a 5-minute break at this point. on the record with our 14th item.
Item 14 is staff of the Public Service Commission filed on August 27, 2018, report on the 2018 procurement improvement process, standard offer service procurement process, case numbers 9064 and 9056.
Good morning again, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. The procurement improvement process is an annual process to make routine changes to the utilities SOS procurements and update the documents that are associated with those procurements. As noted in staff's report, agreed changes include explicit instructions for excess bid elimination, bid confirmation procedures, and the minimum performance insurance increment change. The parties in the process also discussed the potential use of surety bonds as bid performance assurance, but this was not agreed for this year, although the parties did agree to work towards having this in place for next year. Staff also made recommendations with respect to the utilities bid acceptance systems, and the utilities agreed to those with one exception. The non-consensus item is a request that the utilities test the virus protection and security systems semi-annually to certify that they have done so. The utility response is that this subject matter is addressed by the Cybersecurity Working Group. Staff does not believe that the particular computer systems used in the SOS bidding are in fact covered in the Cybersecurity Working Group, however. As the utility's response to staff's report indicates, the working group addresses information technology, operations, and control systems, and we don't consider the SOS bid system to be within any of those categories. I would also note that even if they could be categorized as within the working group scope, that would not yield the frequency of testing that staff has requested. Finally, I would reiterate that given the problems that we've had with the bid acceptance systems and the lack of a requirement that those systems be upgraded, what we are asking here is a bare minimum of what we believe should be done.
Thank you, Mr. Spivak. Does Office of the People's Counsel wish to make any comments? Mr. Fields? Wherever you're comfortable.
Yeah, I don't have long, extensive comments. We basically support staff on this point. It seems like a reasonable request to us, not particularly onerous as far as the request itself. And we also agree with staff in response to the utilities position with regarding to the cybersecurity working group, which which is a matter before the commission. It hasn't been determined. The commission hasn't determined their path for that yet, and we think it would be a better way to go for the commission to establish this requirement to give us better confidence in the security of the SOS bidding systems. And then as it deals with the working group report, if that needs to be amended, that could be amended, but we would have some assurance in the meantime with regard to the SOS bidding. So those were our comments. Be happy to answer any questions.
Thank you, Mr. Fields. Do counsel for the utilities have any response with respect to either this narrow issue or the report in general?
Just very briefly, Mr. Chairman. And first of all, good morning. Matthew Seegers appearing for Pepco and Delmarva. Appearing with me is Bev Sikora on behalf of BGE. As we noted in our comments, the PHI utilities and BGE support the adoption of the staff's PIP report, with the exception of the requirement that the utilities test the virus protection and cybersecurity of their SOS bid platforms on a semi-annual basis. As noted in the PIP report, the issues of virus protection and cybersecurity are being broadly addressed by the Cybersecurity Reporting Working Group, who filed a final report on April 6th, and which the Commission noticed for comment on September 11th of 2018 in case number 9492. In response to your question, Mr. Chairman, staff and OPC both assert that the Cybersecurity Working Group does not include an explicit responsibility to test the security of the SOS bid systems. However, it's worth noting that both the PHI utilities and BGUs use outside vendors for their SOS bid platforms, and the cybersecurity review will specifically include the utilities' procurement practices to manage cybersecurity risks from vendors, as noted on page 8, number 5 of the Cybersecurity Working Group report. So we certainly feel that that category would encompass looking at the cybersecurity and the virus protection of the outside vendors for our SOS bid platforms. Concerning the frequency, as I noted, the Commission just noticed the Cybersecurity Working Group report for comment. If the Commission believes that more frequent reporting is necessary, not only on our SOS bid platforms, but for any of our IT systems, be it our AMI networks, our customer information systems, then the Commission certainly has the ability to and the authority to require more frequent testing. So you have the Commission has our comments. I'm not going to reiterate every point in there, but for the reasons that I've stated and the reasons that we stated in our comments, we feel that the Cybersecurity Working Group report is the appropriate place to look at the cybersecurity and virus protection of our SOS bid platforms. And we are here to answer any questions you may have.
And I think you summed it up nicely. Is it appropriate to be addressing these issues with respect to the SOS auction functionality in this working group, this broad working group as you described, or should it be tackled separately on a parallel track? Do commissioners have questions?
Maybe it goes just is there a harm to doing this? I mean, I take your point that there is the broader work group, but the procurement work group was specifically looking at the very specific concerns and issues with maintaining the integrity of the SOS bid process. So the way I'm looking at it now, it seems if this group that's focused on that, and they see this as an important aspect of maintaining the integrity of this process, that carries a lot of weight with me. And so I would ask, is there a harm to maybe having this dual effort? I mean, it sounds like perhaps something or what you're doing already on the broader group may meet this concern. But again, can you tell me, is this an onerous new potential responsibility?
I'm not sure if there's any harm in, to answer your specific question, Commissioner, I'm not sure if there's any harm to it. It's just that we have not seen any justification in terms of why SOS should be split off from all of our other information, or IT and operating technology systems as a standalone. The cybersecurity working group report, as I noted, will look at things like our AMI systems, our customer care information, where all of our customers' confidential information is. So we just haven't seen any justification of why it should be split off as a standalone. And I would also note that, as we noted in our comments, that while speaking for the PHI utilities, we may have encountered issues last year with our SOS procurements, those issues had nothing to do with cybersecurity or virus protection. So it almost seems like this is a solution that's in search of a problem. So it's for those reasons why we just don't see any need to separate SOS from all of the other issues that the Cybersecurity Working Group would look at.
I think Mr. Spivak would want to respond on that point, and then Mr. Trapp.
Actually, can I add before you let Mr. Spivak go? I think we're also looking at it from an efficiency standpoint, and that if we're going to be dealing with this, and again, perhaps doing a certification, but I guess it's if you then have questions about the certification, if staff, the commission want to know more about what exactly that means, then because cybersecurity and that whole area is so sensitive, again, we do this generally, behind closed doors with the commission so that, we're not telling the entire world how we go about our cybersecurity protection, that, we could then be doing cybersecurity briefings for SOS just that specifically when it comes up once or twice a year, and then we're still doing it every 3 years. So I guess, again, rest assured, we are not waiting, we're not doing a cybersecurity or virus testing twice a year. That's a daily ongoing, thing at Exelon. We are monitoring everything that it could potentially impact any of our systems continually. So it's not like twice a year we say, we're having bidding, let's do a cybersecurity or a virus test on these particular systems. So again, it's more just if it goes on a path where we start getting asked questions about this during the SOS process, it just becomes very inefficient and, potentially confusing, because you'd be asking questions just about SOS, and really the questions are specific or are more global to all of our cybersecurity practices.
Mr. Spivak.
Well, what I hadn't really heard in all of what the utility said is that the specific systems that we're talking about here, which are, to my understanding, separate from the utility's other systems generally, are going to be tested regularly. And that's the assurance that we're looking for here. And I think I'll just leave it at that.
Mr. Trout.
Good morning, Mr. Chairman, Commissioners. Jeffrey Trout for the Potomac Edison Company. We stand in a slightly different position than the other companies because we do not use an external vendor for our bid platform. We manage that entirely internally. And so we supported all of the consensus items in staff's report with respect to the standard offer service procurement improvement process. We also did not have a problem and do not have a problem with staff's recommendation on the non-consensus issue because these are internal systems that are, like Ms. Sikora just alluded to with respect to the Exelon companies, tested on a very frequent basis. We're already in compliance with what staff is recommending, so all we do is just tell them that we were in compliance. On the other hand, the suggestion made by the Exelon companies, which I gather is driven by the fact that they are using an external vendor, that this issue be dealt with all other similar cybersecurity issues in the new docket that the Commission just recently opened. There's a logic to that as well. So we can do both. We will do whatever the Commission directs, but I wanted it to be clear that we are not objecting to staff's recommendation if that is the choice the Commission makes, because we're already in compliance with it.
Thank you, Mr. Trout. Additional questions of the panel? Thank you. It may seem like belts and suspenders, but I would support the staff's recommendation in this case. There may be some inefficiencies with having these two parallel tracks of cybersecurity review, but I don't think it's fully within the scope of the working group to consider these issues related to the SOS auction and to maintain its integrity. So for that reason, I feel more comfortable with the additional protections by having a standalone process in this case. That's where I would vote.
And I would agree with that. The procurement improvement process was set up specifically to look at the unique issues that may arise with the SOS bid process. So I would be inclined to support whatever recommendations they might make to ensure the integrity of that process. So I support the staff position.
Commissioner Linton.
Yes, thank you, Mr. Chairman. I'd also agree. I think that, as you termed it, it's belts and suspenders, but I think there's a value to having this process move forward a little more expediently.
Thank you. Is there a motion?
Yes, Mr. Chairman. For item number 14, I move we approve the 2018-2019 SOS bid procurement documents attached to the report on the 2018 procurement improvement process and approve the bid acceptance system testing.
Is there a second?
Second.
All in favor?
Aye.
The motion is approved. The last item, Madam Secretary.
The last item is item 15. The Potomac Edison Company filed on February 15, 2018, reported the impact of the Federal Tax Cuts and Job Acts of 2017, case number 9473.
Parties would like to take a seat. Mr. Spivak.
Thank you, Mr. Chairman. It seems I'm having all the fun today. This last item stems from the passage of the Tax Cut and Jobs Act of 2017. Early this year, shortly after the passage of the act, the Commission issued an order that required the utilities to file plans to make changes in their rates to conform to the act and pass those savings back to ratepayers, and also, to the extent that it could not be done immediately, to track the tax savings from the beginning of this year in the form of a regulatory liability. We're here before you today with respect to Potomac Edison's treatment of the tax savings that come from the Tax Act. Staff has made a recommendation to the Commission in staff's filing and comments from August 17th. We believe that recommendation is consistent with what the Commission has done for all the other companies it has addressed to date. And that is the basis for our recommendation. I will not go on at length through our comments, but I would like to just reiterate two quick points. One is that we believe it is appropriate to do as staff recommends and return the regulatory liability as a one-time credit, and that is for consistency's sake, as well as the fulfilling the broader goal of bringing ratepayers benefits from the Tax Cuts and Jobs Act as sooner rather than later. So that's our basic position. If the Commission is inclined to defer this to the rate case, we do not have a problem with that so long as it is clear that the regulatory liability is to be returned to ratepayers, and that it is clear that there should be a carrying charge component on that liability from January 1st, 2018 through the end of the rate case.
Thank you, Mr. Spivak. Office of the People's Counsel, Mr. Raker.
Yes, Mr. Chairman, Commissioners, good morning. We're still just about in the morning. We filed comments as well, and as we noted in our comments, we recommend that the Commission reject the recommendation made by staff in their initial filing in response to PE's compliance filing. We believe that the most recent base rate case filed by PE is the best venue to, one, determine the full impact of the TCJA on customers, and two, most accurately allocate all savings to the appropriate customers based on PE's most recent class cost of service study. In our comments, we do request that the Commission direct PE to continue to track the impacts of the TCJA and promptly notify the Commission if any additional impacts are discovered, and that's in line with the recommendations we've made in the past. And we've also reviewed staff's most recent filing on September 17th, 2018, and in that filing, staff notes that, and as Mr. Spivak ended his comments with, that to the extent that tax reform is moved into the rate case, staff suggests that customers should be entitled to the entire accrued regulatory liability. We agree, and in that effort, we support staff's recommendation to include a carrying charge on the regulatory liability created as a result of the TCJA. We also agree that the carrying charge should go back to January 2018 and should be calculated at the company's current 9.68% rate of return.
Mr. Raker, is your position that we can't currently figure out what the appropriate credit would be at this point in time?
We may be able to estimate that amount, but we believe that amount would be most accurately determined through the rate case. And then the secondary point is not only in terms of what that amount is, but how do we allocate that amount to the customers. And we believe that the most recent class cost of service study would greatly aid in that effort.
Okay. Good morning, Counsel for Potomac Edison.
Good morning, Mr. Chairman and Commissioners. Joseph Curran on behalf of the Potomac Edison Company. I'm also joined here this morning at the bench, or the trial table, with Ray Valdez. Mr. Valdez is a witness in the current rate case, which is before the Commission, and is also the Director of Rates and Regulatory Affairs, and is prepared to answer any questions you may have about our filing as well. Just not to reiterate and repeat everything we had in our filing of last week, but as we indicated in our February filing before the Commission, we have both tracked as a regulatory liability the current impacts of the Tax Act and continue to do that and have done that in our rate case filing. As we explained back in February, Your Honor, our plan was to address the full impacts of the Tax Act as well as all the other costs, investments, and expenses that are the subject of that rate case in the rate case proceeding, and believe, as OPC does, that the proper venue to consider all of these issues is in the rate case and not to bifurcate those proceedings. We believe that overcomplicates not only the current Tax Act filing, but also the rate case, that these issues all should be handled as they traditionally are in a rate case proceeding, where you examine all costs, investments, and expenses and determine what are the appropriate rates. So without, again, repeating what we put in our filing, we still contend that that's the appropriate venue to consider these issues. One of the concerns that staff has raised to try to distinguish us from the way the Commission has treated prior Tax Act filings is a concern that there will be a potential windfall to the company by not acting on a credit at this point. And clearly, as you can tell from our rate case filing, as well as our earned return reports that are filed with the Commission, the Potomac Edison is currently substantially and significantly under-earning, even with the impacts of the Tax Act. So following staff's advice would only exacerbate that issue prior to the ultimate outcome of the rate case. So again, we concur with OPC that the proper venue for consideration of all of our costs, including the rate case, the tax asset impacts, is in the rate proceeding. And happy to answer any of your questions.
Recognizing that we have a rate proceeding before us, and we have yet to have the pre-hearing conference, it'll be many months before the Commission reaches its determination on Potomac Edison's rate case. One of the goals, the intents of H.R. 1, the Tax Cut and Jobs Act, was to return overcollection taxes to the pockets of public citizens as quickly as possible. And most every utility in the country came in relatively quickly in the beginning of the year, January, February, to make filings to do so, whether they be here before the PSC or before FERC, the federal regulator. Recognizing that Potomac Edison hasn't filed a full rate case in about a quarter century, is that really relevant to the situation here? Isn't that just either maybe it was coincidence, maybe it forced the utility's hand to come back in light of its current under-collection status?
Absolutely, it is relevant. It is one of the drivers for necessitating the rate case. And like any other expense or costs, taxes that are passed through, that are collected from customers, are collected from customers by the utility and returned to the government. This is like any other cost that needs to be examined in the context of a rate proceeding. And this is not that unusual. I know that certain other utilities came in before the Commission and provided immediate relief. You have to also remember that Potomac Edison hasn't been in for rate relief in 25 years. Those other utilities that were before the Commission earlier this year have had recent rate cases, have had more mature and fully vetted cost of service models and studies that have allowed them to make that allocation. We would really be basing our decision on a very stale cost of service model, which is going to be litigated in this case. And to your point, Your Honor, regarding many months from now, we filed the rate case in August. Under the Commission's a time clock, a final decision by the Commission would be rendered March 22nd. So we're not talking about an extensive period of time, but as we traditionally do and avoid single-issue rate making, we examine all components of a rate case, all costs, all expenses, and we'll be litigating with staff and OPC the cost of service model, and at that point, once we have a fully vetted cost of service model, we'll know how to make that allocation. And you shouldn't be concerned that the company's trying to skirt or get around the tax act implication, because we are following your directive, tracking that regulatory liability from January 1st and through the rate case. So there's no diminution in the responsibility of the utility. All of those issues will be fully vetted and will be once and done. So instead of bifurcating these proceedings, having a credit now, then making us request an additional for additional relief in order to make up for that deficit, we should treat this all at one time and do it in a once and done fashion, and not a bifurcated fashion.
You make a good point with the yo-yo effect and the fact of making a credit now and then having a higher than otherwise rate increase down the road. But I still think about the intent of Congress to return funds, an overcollection of tax funds as soon as possible to customers. And most utilities did that through some type of one-time bill credit and then a reduction in rates going forward. Here your argument is that we'll just take this up in one rate case, and the benefit of the reduction in the corporate tax rate would result in a reduced overall rate to your customers.
And this is not unprecedented either. I know that you've made exceptions for the other utilities to make these rate reductions outside the context of a rate proceeding. But also, as you recall, PEPCO, the Commission handled its Tax Act reduction within the context of its rate proceeding earlier this year, and is currently considering the same treatment for the Mid-American Water Company, or Mid-Maryland Water Company, so doing the same thing in the context of a water case, and a similar treatment that you treated the impacts of the Tax Act within PEPCO's recent case. So the company did come in, quite frankly, as soon as it could. It's coming in August. That case is before you now. There will be a decision in short order in March, and really think, as OPC presented to you as well, it's best to handle these issues in a consolidated form. And the other point I would make to Your Honor, if we go the route of doing a credit now and then have to increase rates later, it becomes fairly cumbersome and burdensome to the Commission within the context of the rate case to try to figure out how to reconcile that credit in the rate case when it was based on, as staff is proposing, on an earned return report and not on a fully vetted cost of service study. So doing it with your other utilities, you had that. You've had recent rate relief for BG&E and others, so you had more of a foundation for how to allocate those costs. Here we're going to be litigating that in front of you all, and it makes sense to make all those decisions within the context of one case instead of trying to do something now and then try to reconfigure or reconcile that action within the rate case. We think that actually lessens the burden for the Commission as well. And quite frankly, for the company, proposing a credit now at a time when the company's under-earning substantially based on its earned return report, you're going to exacerbate that for the 4 or 5 months until there's a conclusion in the rate case, putting more pressure on cash flows for the company and the credit metrics as well. So we ask you to take all of that in consideration, and really not to do anything that is unusual, but do what you would normally do and not base a decision on single issue rate making, but make decisions on costs and expenses and investments, all within the context of a fully litigated rate case.
Thank you, Mr. Spivak.
If I might, Mr. Chairman, to the extent that the company is saying that the regulatory liability essentially should just be considered one more item in the overall picture of the company's finances, staff disagrees. It should be clear from the outset that the regulatory liability is something that will be returned to ratepayers, whether you do it now or whether you do it in the context of the rate case. That those tax savings have occurred. They were not intended to increase the company's rate of return over the period before they are given back to ratepayers, but that they have occurred and they should be returned to ratepayers. With that, and provided appropriate carrying charges are paid, we would not object to it being considered in the rate case. On the other hand, we believe it's more consistent with what the Commission has done for other utilities to do it now. And I would note as well that in the case of Pepco, the rate case was right there. It was already happening at the point where the Tax Act occurred. It had been filed right around that time, so, or shortly afterwards.
Thank you. Questions, Commissioner Richard?
Yeah, I think OPC, you basically answered the question. I just wanted to just probe a little bit, though. As Mr. Spivak says, this money is owed to the ratepayers now, and so it's just sitting in the accounts of the utility. Wouldn't it be inconsistent with how we've treated these funds for the other utilities to wait? And why would we do this differently than the way we've dealt with these owed funds with the other utility? I mean, I'm just trying to understand why on this OPC is taking this position, other than, yeah, we do have a rate case early next year.
And so that's a very fair question, Commissioner. It's a very delicate balance that we weighed out here. Certainly, we're always of the opinion that if funds are due to customers, they should be returned to customers as soon as possible. But in our other filings, we've also recommended that the company should come in for rate cases in order to fully understand the impact of the TCJA. And it so happens that at this point in time, PE has filed a rate case, and the refunds from the TCJA have not been returned to customers. So we're in sort of this odd situation. And so we continue to feel that the rate case is the best avenue to fully understand the amount of the impact from the TCJA that should be returned to customers, but also importantly how they should be returned to customers. And with that in mind, we continue to recommend that those impacts be handled in the rate case.
Okay. And you don't see any kind of concern here of any precedent in treating these otherwise pass-through costs, the taxes, as if there's some kind of a fungible variable that the utility could use at will to, again, for any purposes such as propping up a perceived under-earning. Does that cause any concern for the Office of People Counsel?
It doesn't, Commissioner, because it's still treated here and will be treated as a regulatory liability that will be passed on to customers. The only question is, what is the most accurate value of that? And again, how should it be distributed to customers? And at this point, I think both questions remain open, and those are the questions that we'll be probing during the rate case.
Okay, well, thank you.
Yeah, I just had one question. Since the company collected these taxes under the allocation that was established so many years ago, why isn't it appropriate to reimburse it under that same allocation as opposed to updating for something new? That's before OPC or staff.
Well, as far as staff is concerned, it is appropriate to do exactly that. That's really essentially what we're recommending here.
If I may add, Ray Valdez, the big problem that Potomac Edison has is that, as already been mentioned, our last cost of service study prior to the case that was recently filed was back in 1994. Potomac Edison looks nothing like it does now. Potomac Edison owned generation. It was a fully integrated utility that offered distribution, transmission, generation. So how things were set up when rates were last changed are substantially different than they are now. So it wouldn't make sense to rely upon something that is nearly a quarter of a century old, because the utility looks substantially different than it did back in 1994, and that's what we presented as a big problem in even determining what the actual amount is. To base it off of a quarterly earned rate of return report is a report that hasn't fully been vetted by all the parties, and so it's essentially taking an educated guess as to what that number might be until that number has been fully determined within a litigated proceeding. If we had filed a rate case 2 or 3 years ago and based it off that, and that class cost of service and income statement and rate base went through the normal vetting process, then that, Potomac Edison look pretty similar now as it did a few years ago, but that's not the case with us. We look substantially different than we did 25 years ago, and the best thing that we had until we filed a base rate case is our quarterly earned rate of return report, which is not a fully vetted document, and so anything that's based upon off that is a guess at this point.
And in response to your question, Commissioner, we have raised, and I think we dealt with that issue in some of the previous tax filings where cost of service studies were outdated. And I think in those instances, it was more of an across-the-board cut. Here, it's, again, a question that needs to be determined. Certainly, from our perspective, residential customers may benefit, depending on the outdated cost of service study, or it may be a detriment to them. And so our position is that the most accurate cost of service study would be the most beneficial way to reallocate those savings.
Thanks.
Well, it's amazing how something as simple as a tax cut, round numbers, what did it drop to, 21%? 21. Results in such complicated numbers here. There's a lot to digest, even though I know that Potomac Edison made this filing in February. Instead of taking a motion today, I would suggest that we take this under advisement and issue a commission order in the near term. How do my colleagues feel?
I agree.
I agree.
Okay, no motion. The commission will take this under advisement, subject to issuance of future order.
Thank you, Commissioner.
Thank you. Seeing no other business before the commission, this meeting is adjourned.